Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
Yeah. Roberta in the truth zone, mic hitting raw. Spotlight shining, she exposing the flaw. Debunking the myth, breaking their facade. This is Glass City, respect the squad. On these NYC blocks where the skyline flex big. Roberta Glass slicing lies with a truth rig. Innocence frosters, your stories unravel. She's a map through the madness of gritty gravel. Glass don't bend and facts don't break. She's a storm that's called, you feel the quake. Exposing tales stitched with crooked seams. Justice in the lens, shattered fake dreams. Screams about killers, painted heroes in disguise. She burning propaganda with fire in her eyes. No glamour for the guilty, she call it straight. She backs victims, the voice stay away. Stats and receipts, no spin, no clutter. Cold cases whisper, she cuts through the mutter. Truth's her tempo, don't confuse the beat. She's standing for the real while you taking a seat. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time to play. She's glass hard, break the false and save the day. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time.
Whoa, 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 whoa. Who has high blood pressure? What a day it was. Roberta Glass family. Who's here? Not many. Everybody's too depressed? Really? Really? I thought you were tougher than that. Let's see the tough ones in the audience. Mia Wallace, my King of Kings. Caroline Lolly, 77. Doing some backup moderation work. Your latex spouse, Taterbug, Scorpio Moon Gal, Murder by Maestro. Thank you, everyone, for moderating. Sandy B, Kate, Tanja, Freak Aaron Reed, Tracy, Golden Grace. Okay. Brady Bro, hello. Strong ones. Strong, fearless listeners. It was a crap day for our side of things. Let's just call it like it is. First, after denying these, I mean, I've never seen verdict sheets like this. If you just want to totally acquit and go home and kick up your heels and get a pat on the back from the huge crowd that Judge Cannoni's allowed outside. What a joke Judge Cannoni is. What a disgusting symbol of injustice she is, right? So the idea of our legal system is that it works separate from our media because it's so easy. We all know how easy it is to fool people with propaganda. We've all been fooled, including yours truly. Fooled. You know, the only one who says they can't be fooled by propaganda, that's the sucker, okay? We all know that we're all fooled every day, not every day, maybe a lot by propaganda. And the idea of our legal system is that the reason we have rules of evidence and we have all these rules in our legal system is so that you can't allow hearsay and propaganda and rumors and sort of. But Judge Cannoni's just let in this let in the campaign by allowing the whole courthouse to become a free Karen Reed concert, essentially, outside. Concert for the deaf. I mean, they're not making a lot of noise, but they're there, putting pressure on our legal system, putting pressure on the jury. It's disturbing to watch. Karen Reed shouldn't want this. See, they have it. See, the way she's framed it is the justice system is so unfair, so why not come corrupt it? She should say, hey, guys, I know the facts will prove my innocence. I don't need anyone to corrupt the justice system. Why is Turtle Boy saying, don't tell anyone, get on the jury, come corrupt the justice system. Let's poison the jury pool. Because the facts aren't on their sides. They can't win in the courtroom. So this is all about innocence, fraud, and why I've been so reluctant to do what I've seen other channels do. Go, oh, you know, the facts are overwhelming. Just relax. Sit back. The justice system's got it taken care of. Sure, we got a very pro-criminal judge, a former defense attorney, former public defender, Judge Beverly Cannoni at the helm. But the facts are, even if she rules all the way for the defense, the facts are so against Karen Reed that they can't twist it. But they have twisted it, and in came today. Please hit the thumbs up on your way in, guys. In came today was just the 4 worst. The first question was the worst, and it was read last. So it sounded like the first 3 were very good. And then we got, so the first question was really, so I'm going to read them say at least the first one in the order it was given, was, can we acquit? I mean, the only worst question for the prosecution would be, can we acquit on all 3 and go home? I mean, if we acquit on all 2, can we hang on a 3rd charge? Sounds like someone was following the trial last time. I'm so upset. Free Karen Reed. Karen Reed's Innocence campaign tainted the jury pool. I don't know who's on there. I thought it was a very poor idea when I heard. You heard me. I mean, it's all on record. I'm not making stuff up after the fact. It's on record. Okay, so for everyone who's like, what is she doing? What is she doing? I said it. I called it. I said, why are we having a jury under 45? This is very bad. Who picked this jury? What was Hank Brennan thinking, picking this jury? All under 45? I think he was thinking, oh, they love data. No. They have been bamboozled. They've had years. I mean, I was listening to Matt to Panic today. He was like calling it true crime media. It's what he's talking about is innocence fraud. And no one wants to call it innocence fraud. What it is because they'll it will actually give me some props, but that's what it is. It's innocence fraud media that has been dominating true crime media. It's so profitable, and it pushes an ideology that they love. They're dying to get rid of life without parole. They're dying to get rid of these big sentences. They're dying to free as many criminals, no matter how disturbing and dangerous they are, like Kevin Cooper, Julius Jones, Rodney Reed, to name a few, Richard Glossop in Oklahoma. It's got to be retried. They're going to give him bail, that guy. He's been victimizing women financially from prison. So, I mean, that is the worst question. Can we acquit on 2? So everybody's been reporting. I don't know if it's true. I'm not in the jury. I mean, I don't know why the media is reporting that they're all hung on manslaughter and want to acquit on OUI. I mean, the woman said she was drunk and shouldn't have been driving. That's evidence. And we will look at the way Judge Cannoni The verdict sheets are awful. You go in reverse from innocent to guilty. I mean, what are we doing? What are we doing? What are we doing in our society? I mean, the jury charge was ridiculous enough, an hour and a half too long. I mean, you can't use your bigotry to make a decision. If you picked a bigot to be on the jury, you're not a very good lawyer. Do we have to read these things out about how you can't discriminate on the base of race or biological sex? They call it gender. It's biological sex. Let's call it what it is. Okay? I mean, what are we talking about here? I love that you're keeping the faith. I love the positive people in the audience. I love my audience. I do have the best audience in true crime is right here. I know I'm a little biased, but I really do think we have the best, smartest audience around. Chat is the best. Thank you, moderators, for keeping it sane. So, I mean, this was just wild. So the way we heard it is like these three other questions that sounded very good for the Commonwealth. Karen Reed's family was crying for 7 minutes, apparently. One was, can we use Karen Reed's own words? Is that evidence? And again, great point by Matt DePanic. Gotta cite him again. He's like, what were they doing when they were hearing him putting that into evidence, each video clip? And it makes me think that they did not get the relevance when he was talking about the sequestration order. I don't think anyone had an idea what that was and what a serious violation it was by the defense. I mean, if you know courts and you've been covering courts from the courtroom, you'll know how important a sequestration order is. But most people, luckily, aren't going to be in our courtrooms and have this kind of knowledge of how important all these rules are and how criminal the defense team is. So it looks like, can she be acquitted on 2 and can they hang on 1? And I think this is the last trial for Karen Reed. It's been so expensive. I can't see them doing this again, but maybe they will. Why were they crying? Because it looked like the questions were, can we use Karen Reed's own words against her? Was the time, I mean, obviously she should have said it was the time of the crime or later that morning. That is the dumbest question in the morning. Of course, it's the time of the crime. Everything has to do with the crime of killing John O'Keefe at 12:25 that night, not 5 in the morning. What are they thinking? Who are these jurors? I don't want to put them down, but I don't want professional juries. I know that there's been a call for that. No, thank you. Are people still thinking we're going to get a guilty verdict? Did you guys watch what happened today, or are you just coming in? Guilty tomorrow on all counts? Vala. I don't think so. I think this sounds like the most free Karen Reed jury you can get. They're hanging, they're arguing manslaughter. I would prefer them to hang on everything than to have what Karen Reed will call, if they get off, this is the way an innocence fraud campaign works. If she gets off on any charges, they will use a not guilty verdict and call it an exoneration. And the myth around this case will be Karen Reed. John O'Keefe was murdered by a dog or some shadowy figure. And we're going to have Sacco and Vanzetti all over again. I mean, we're teaching our children that myth, that they were. I lost my faith with these jurors. They are too young. Yeah, young. I don't know who's on there. When Karen Reed said, I don't know if you were there when I went over it, she said, we picked these jurors. I said, Well, what do you mean you picked them? Didn't the Commonwealth pick them? That scared the heck out of me. Is there a free Karen reader? Are there stealth jurors? Sounds like it. Sounds like they were all super familiar with a lot of it and lied to get on the jury. That's what it sounds like to me. Let's take a listen to what happened. So here are the questions. They came in opposite order, but this is how it went down. Then you can listen how did Judge Canoni change the jury sheet. We'll go over it. I hope my computer is kind of on the fritz today. I hope it'll work. Let me just... Yeah, I'm already getting nervous. Hopefully it'll work. If not, I'll just chat. Lolly 77, justice for John and the O'Keefe family. I agree. Thank you for supporting the stream. All these episodes are made possible by you guys. Links in the description of this episode. I have a feeling I have a lot of free Karen readers hate watching and enjoying the suffering. They're enjoying the suffering of the other side. It's hard. Yeah, it sucks, guys. What can you say? I'm not going to sugarcoat it. I call it the way it is. This was a great day for the defense. So apparently they were really upset and worried when these questions came about, I believe. Very red, Daddy Reed, etc. Cut to the chase. If you're listening on podcast, there's Daddy Reed sitting next to Karen Reed's mother and Ingrid Miller, also known as Ingrid Curtis, also known as Bud in her phone. Karen Reed texted, free Karen Reader, saying, Mama Reed, don't worry, behind her. All feeling very positive that, I don't know, do they know who's on the jury? That this is going to be positive for them, but that, yeah, you can see Ingrid Miller is very teary-eyed. Yeah, there he is, wiping his eye a little bit. Yeah, they're wiping their eye. It's about 7 minutes. We're waiting for the jury to get in. And the lawyers, hold on one sec. Let me move forward. So then we saw them. They were at sidebar. And we didn't know what the questions were. I'm really sorry. My computer is a little wonky today.
4. Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What I'm proposing, I gave you both a verdict slip where I included the language. I know yesterday I said they have to be read hand in hand, the jury instructions with the verdict slip. I've incorporated the language from the jury instruction into the verdict slip. I've given each side a copy. When I come out, I'd like your input on whether you think this is appropriate. I would instruct them, as I did before, that they start at the top and work their way down. That's the only thing I did not specifically put in here, but I think it takes it step by step.
I mean, these verdict forms are ridiculous. They're so pro-criminal. I mean, you have to push through to guilty. Like, push through. Do you want to acquit him here? Everything's over if you acquit him here. You go to the end of the page and just sign it. But if I mean, she has done everything she can do, this judge, to get Karen Reed off. I don't know what more she can
an analysis to do it. So how much time does the defense want to be able to respond to me?
Perhaps 15 minutes.
Okay. And the Commonwealth?
That will suffice.
Okay. So it's 7 past. Why don't I come out at 25 after, give you 20 minutes?
Thank you, Your Honor. If you find the
question, are the video clips of Karen's interviews evidence?
Seated, court is in session.
All she had to say is yes. Are the video clips evidence? Yes. 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 End of story. What does the defense have to do with yes? They know that they can ignore or deny. Wait, they've been charged for an hour and a half. I don't know what happened to Hank Brennan today. He didn't seem to come to fight. It seems like he came to let Karen read off. There was no fight. He had some quit. He had a lot of quit today. Sorry, Hank Brennan lovers. I was not impressed.
All right, so I will hear.
Where is Adam Lally? Get Adam Lally up there if Brennan's having a bad day. We all have our bad days. Get Laura McLaughlin up there. She is a dynamo. She is a dynamo. She knows this case. Get her up there. Where is the passion? Where is the fight? And this is what, and I don't think cases are won on opening or closing arguments. So I'm not saying this is why we're in this position. Because of 1 minute moment. But where is the fight? Where is the passion? For justice for the O'Keefe family. Put this psychopath away. I mean, this is not justice for John O'Keefe. It's the closest thing we have. Closest thing we have. We can't give Karen Reed the death penalty, eye for an eye. Is that even real justice? I don't know. Let's not go into that. Certainly closer than 5 years in jail, 10 years in jail, 20 years in jail. Nothing's bringing John O'Keefe back. John O'Keefe's family have been already sentenced to a life sentence of grief and trauma. Karen Reed was merciless. This is the way we treat the O'Keefe family. What a sad day for justice, the state of our justice system. And this is every Innocence Project, every wrongful conviction group, every documentary, Sarah Koenig, every little piece built this monster. It's like a Frankenstein monster of what the innocence fraud movement has put together. It's the outcome.
Hear you on the first question, the time of the OUI. Any suggestions?
Your Honor, do you want to hear from the defense first?
I'll hear from you're standing up, so I'll hear from you first.
Okay. On question number 1, what is the time frame for the OUI charge, offense 002, section 5, OUI at 12:45 or OUI at 5 a.m.? Our suggestion would be something along the lines of, ladies and gentlemen of the jury, you have the evidence. It's your decision.
You are the fact finder.
You're the fact finder.
Look at this. I mean, my boyfriend Brandon was like, why is she letting him walk all over her? Why isn't she telling him to sit down? Why isn't she in charge of her courtroom? Who's in charge? The defense team's in charge. That's who's in charge. Funny Bunny says if they hung on manslaughter but agree on the lesser OUI, disgusting. Can she be retried for manslaughter? Yes, but no, she won't be. I don't think. Sorry to be a downer. I'm really sorry, guys. We'll be strong. We'll get through it. After this, the civil case is coming. And maybe there can be a larger understanding of how scary and dangerous this kind of witness harassment campaign, this innocence fraud campaign is. Maybe people will wake up. Some people. Chloe Parker. CA. Hey, how is Canada? Turtle Boy will be our Ghislaine Maxwell. I think the blue side will finally be mad enough. We want justice. This injustice is not over. Yeah, the civil case. That goes to trial. It will hit Karen Reed where it hurts. What matters to her, money. I mean, if you look at the way Karen Reed looks, just look at the pictures, from the older pictures to the newer pictures. She is so Botoxed and done. I mean, she looks like movie star. I mean, she's very thin, so that can make you very photogenic. There's no lumps or bumps there. But I mean, she's been so Hollywoodized from the early Karen Reed pictures. She's like glamour girl in these, outfits. Chloe Parker. Yeah, I hope so. I hope it will wake people up. How's everybody else feeling? Let me check in with you guys for a second. Today, right, she looks so different, right? Doesn't she? Oh, her life isn't over. She will continue to profit off her crime. And she'll continue to be treated like even more so like a celebrity by her press. Look at the way Amanda Knox is treated.
Mr. Brennan, or whomever from the Commonwealth?
My suggestion would be 12:45.
And why is that?
The case has always been focused at that time. I don't think there's anything specific in the.
There's nothing about 5 o'clock. 5 o'clock isn't when the crime is done. She's not here for what she did at 5 o'clock. She's here for what she did at 12:25. What are we talking about? Sorry, guys. If he won't have any passion, I will.
Regarding the time.
Do we have the indictments?
No.
I do want.
If it's not in the indictment, I'm uncomfortable telling them a time.
I'm sorry?
If it's not in the indictment, I'm uncomfortable telling them a time.
Understood.
All right.
I agree with the court on principle. I just don't have the indictment memorized, so I don't remember if we can pull that up.
There's no time? I don't expect that there's any time. To be
All right. So I'll say you have the evidence, and remember, you are the fact finders or something.
What? This is called a criminal trial. When you find the crime occurred, there's no crime at 5 o'clock. She didn't leave the scene. It's not because Karen Reed left the scene 5 o'clock. I mean, what are they talking about? Yeah, why wasn't she charged twice for a DUI? She did drive drunk twice. It's kind of a good point. Kind of a fair point. Why didn't she have 2 charges for that? Why is it all considered one charge?
Something to that effect. All right.
Right, but as Jennifer Harmon says, it's an automatic felony in Massachusetts. They don't follow the law in Massachusetts. It's just anything goes. If an OUI is an automatic felony, apparently not. Apparently, it's like a misdemeanor if it causes death. Because they didn't find that she caused death. They didn't find in the other charges that she caused death, Jennifer, even though we know she did. And they might say it happened at 5 o'clock.
Are the video clips Karen's interviews evidence? How can we consider them? So I'll tell you what I was planning on saying, then you can add to it.
Sure.
Yes, the videos are evidence. Give them whatever weight you think is appropriate to give them. And then I would give the digital evidence instruction and the humane practice instruction.
The only thing I would respectfully ask the court to include in that sentence is give them whatever weight, if any, you deem appropriate.
All right.
If any.
Okay.
Thank you. Otherwise, it's fine.
Yeah, Jesus should be returning with this kind of injustice. This kind of return of the psychopaths. We got 900. I mean, this is we've broken records today on watching. I don't know who's watching, but we're breaking a record. Never had so many people watching on a 6 o'clock show live. I mean, I think some of them are free card readers. Now it's going down, but it was up to 900. This is now hovering in the 898 category. We got 536. Yep, it's back up to 900. 536. Hello, everyone watching on X. Only 364 in YouTube, but a ton watching on X. Hello, everybody.
Okay. What's the Commonwealth's position?
We have a different perspective on that.
Okay.
The first part of the question, are the video clips of Karen's interviews?
We have a different perspective. How about no thanks, Judge? No. He just didn't bring the passion. Where's the passion, Hank? He can be stronger than this.
Evidence? The answer should be yes.
Okay.
How can we consider them? I think it's fair to say you should weigh the defendant's statements as you would evidence. Since they've been introduced substantively, they are like any other piece of evidence. There's no difference, and there shouldn't be any reflection of a difference in the answer. We didn't introduce any evidence in this case and say you should give it any weight, if any at all. We didn't provide a limiting instruction anyway.
Right. They don't say, here's the evidence, take it or leave it. They decide what weight they give it. They know that. They should know that. Who is this jury? You just say, yes, it's evidence. It's evidence. Yes. How about yes, period? Yes, period. My suggestion. Yes. Is it evidence? Yes. You've already been charged for an hour and a half with a zillion pro-criminal limitations. Judge Canoni, please spare me.
Anyway, and these shouldn't be so limited. This is just like a photograph. It's no different than a physical piece of evidence. And so I think the answer should simply be yes. You should weigh the defendant's statements as you would any other piece of evidence. I do not think the court should give humane.
You know, she had a run there of, anyone else, it would be like, would just say, stop whispering through the whole thing. Judge Canoni, anything's allowed. The reason you have legal pads and you have paper so you can write each other notes so you don't have to talk through each other's arguments. Judge Canoni, Wild West. Wild West. Another judge would chew you out for that. It's so demeaning to the other lawyer. I mean, I'd love to see Alan Jackson with the prosecution team whispering and talking and being really animated through all of his arguments to the court. Love to see that. Alessi, I mean, you move your hands a certain way and he freaks out while he's talking. Person of the Year, Canoni. And also, I think also this is also what happens when cameras get in our courtrooms. I used to think it was great that everyone would learn about the facts of the case and the legal system, and people would learn how our system is done. It's very different, first of all, watching in person and then watching on TV. Your brain gets trained to pick things up very easily when you're actually in there in person because you can't rewind. There is no tape. Will never be any tape. There'll be a transcript, but no tape. So it trains you to get very observant and very sharp, and also learn things, get an ear for the court. This, because you can go back, it makes it a spectacle. It turns it into something else. I'm not really for cameras in our courtrooms as much as I enjoy it and much as I rely on it. And I wouldn't have much of a show without it. I guess I would be doing kind of shows. I guess I would be at the Diddy trial now. That's how it would go. Oh, my boyfriend wants to say something. What? Okay, there was a kitty emergency. Okay, here we go. Back to Karen Reed.
In practice or digital evidence, it suggests that there's some deterioration or further analysis that is different. Those instructions were already given during the charge. In addition, those instructions are in their hand in the written jury instructions. And so, to put it most simply, as I think that we should, is this is a piece of evidence and you weigh it like you would any other piece of evidence, whatever they decide, rather than give them guidance to court.
I mean, they're whispering so loud. This is not the court reporter. Okay. They're whispering so loud it's hard to hear Brennan. Unreal.
Kill it or to limit it in any fashion.
My only suggestion, Your Honor, is that every single piece of evidence that's provided to them, it's in keeping with Massachusetts laws and keeping with the responsibility that they have. Every single evidence is given the weight, if any, they deem appropriate. That is not a misapplication of the law. I think the Commonwealth.
No. You're telling them they can ignore it all. They already know that. They should know that. You don't say, here's the evidence if you accept it.
Suggestion suggests in the answer that they should or they have to give those statements weight, and the law is they don't have to give them any weight. So I think the appropriate comment by the court is exactly as the court suggested initially, which is you give it whatever weight, if any, you deem appropriate.
Why are you mad? Are you mad at us? What did we do, Chloe Parker? I hope you're not mad at us. Just found you all, but I'm mad. Yeah, you should be mad. You should be mad. You're watching an injustice unfold in real time. It's hard. It's difficult. I've been down this road before. And now this will become a myth, and people will think that this Karen Reed was innocent. It was an iffy case. I mean, that's what they're saying about the first trial by people who didn't watch the first trial. Oh, hello, everybody who just joined us. I mean, this is... Sorry, I'm just shocked by all the people watching. I'm shocked. Hello, everybody. Lazy Susan. Jurors should take a drive with Karen before convicting. Well, she'll probably charm them all, unfortunately. Penny says there sure are a lot of people drinking the Kool-Aid. It's an innocence fraud campaign. So what we have really disordered and dangerous people. People who have criminal backgrounds themselves who've driven drunk and gotten caught. There's also people who hate the police. Then there's good people who've been propagandized by our media. They've had a war on the police for years and years and years. When's the last time you heard about a sweet story about a policeman helping someone? You know, that's the way I was raised, in a radical left family, activist family. Hate the police, don't trust the police. You know, they're like any other profession. There's good policemen and bad policemen, but it is a job. It is a very hard job and a very necessary job. And I love when these anti-police people need help and call the police. That's who they call. They don't call a mediator. There was a talk during all those BLM riots and Antifa. I hope nobody else ever gets to come across Antifa face to face. That we'd have like mediators instead of police and defund the police. It doesn't work. And you know who it hurts? It doesn't hurt the gated communities, the people in gated communities. It hurts poor people, disenfranchised people, poor neighborhoods, people, Black neighborhoods, Puerto Rican neighborhoods. The people, it hurts the very people they say they are trying to help. It sounds like we've got a whole jury full of Ronnie the EMTs and Victoria Georges. That's what it sounds like. We've already been through this. Sorry. All right. I'm going to keep it brief. Anyway, let me try to go to where she comes out with the actual, where she reads it out. Sorry, guys.
Should weigh the defense.
Okay, here we go. Sorry, I forgot about this long pause while she was writing.
All right. So what I'm going to say is, yes, the videos are evidence. You should weigh the defendant's statements as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, then I'll go and I'll read the electronic communications and the humane practice. That covers it.
If the, I don't have a principled objection to it if the court adds the word "if any."
I understand.
Because I don't want them to think, for instance, the way that it's worded as the Commonwealth suggested it, they have to weigh it the same way they weigh other pieces of evidence. Every single piece.
Why didn't we ever see Hank Brennan do this? When it looks like Judge Cannoni's going to rule against him pushing through. We've never seen Adam Lally do this. We've never seen Hank Brennan do this. The only person that does this is Alan Jackson, and he wins because he does this.
of evidence is weighed in and of itself. It's individual to the piece of evidence that's presented. For instance, they could weigh the statements by Ms. Reed. They could give it no weight. Each individual juror could decide, I'm going to dispatch it altogether and give it no weight, while giving another piece of evidence like.
But why don't we ever see the Commonwealth this passionate that they just won't give up? Why are only the fraudster lawyers the only ones who are doing this nonsense?
Whatever that.
I mean, it's not nonsense. It's like you're passionate about it. Why don't we see this kind of passion from the Commonwealth? Just asking the questions.
Might be the testimony of one of the ARCA witnesses, complete weight. I think that we need to stress that the clips bear no additional weight, no additional gravity than anything else that they've considered. And the only way to do that is very simply, you give this the weight, if any, that you decide is appropriate. It doesn't, I think, comparing it and contrasting to other pieces of evidence in the case, it's unnecessary, and it tends to suggest they have to give it weight.
Okay. So your objection's noted. Now let's get to the third one. Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What do you want to say, Mr. Jackson?
Your Honor, I appreciate the effort that the court went to amend the verdict slip as it relates to count 2. And I think there are some excellent suggestions by the court in the verdict slip. By and large, I think question number 3.
Terrible. The worst verdict slips ever. Listen to this.
Is answered by the amendments in the verdict slip. So we certainly could say something like, does convicting guilty, the question was, quote, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? The answer is no, obviously. And perhaps we could formulate an answer that says something along the lines of no, new verdict slips have been provided that will make it more clear, or something of that nature, as well as a decision of guilty on the OUI charge.
So if you're listening on podcast, or if you're not watching, Paul O'Keefe is throwing daggers from the back row to Alan Jackson, as I would too if I were there.
002, number 5, is an explicit acquittal on the higher charges in offense 002, which is a proper statement of the law. And then there are suggestions that we have regarding the edits that the court has made.
John O'Keefe's family and friends seem to be universally in blue today.
Made to the verdict slip. And I'm happy to go over those with you and put those on the record.
Okay, go ahead.
With regard to going from the top to the bottom, just under number 1, number 1 reads, not guilty of the offense charged or any lesser included offense. We would propose that the court add the consistent language that it's added throughout the verdict slip. If you, quote, if you find the defendant not guilty of the offense charged or any lesser included offense, comma, stop and sign the verdict slip, period. That's the only place that that language doesn't appear, and I think it should appear.
Okay.
The second is a relatively minor issue. However, under number 2, sub 2, the parenthetical.
No, they asked. Maestro says the only thing we know is they're not coming back innocent. First of all, there is no innocent, not guilty. They said that can they quit on 2 charges and hang on another charge? Yes. Okay. All right. Yeah, it looks really bad. Whoop. Really bad.
Check one or both of the following. I think it should say, just to clarify it further, if guilty, comma, check one or both of the following.
All right, I think I'm going to leave it because it appears only under the guilty.
It appears only on,
Under the guilty. So go ahead. I'll hear you further.
going further, going under number 3, toward the bottom of the page, in the parenthetical that the court suggested, which we find is excellent. If you find the defendant guilty of the lesser offense
Okay.
of involuntary manslaughter, we would simply add that clause.
So we'd have to add it in all of them,
Correct.
which makes sense. I think
Correct.
we had it in the first one.
Right.
Okay.
And then moving to page 2, at the top of the page under sub 4, again,
Hold on one second.
of course.
So, right. So let us remind that the criminal trial is only one part. Her innocence fraud campaign, she can win this. She can win a lot of book money, but if she loses the civil suit, all that book money, all the documentary money, anything that she makes is going to go to the O'Keefe family. There's a happy thought for you all. She will live with the O'Keefe family over her. And if you don't think that the O'Keefe family wasn't preparing for the worst with this civil case, and I think really what they wanted to do, and unfortunately, again, another terrible decision by the judge, I don't think she should have had a right to get to deal with this first. I think she should have been deposed like every other civil defendant and let it be used in the criminal trial. Why does you notice no one else? I mean, why is Turtle Boy allowed to plead the fifth? Why is in this? I'm really sorry they didn't bring in the witness harassment campaign. I'm really sorry they didn't bring in the domestic violence issue into this and have a domestic violence expert testify about the relationship and the dynamics and Karen Reed's makeup. Because that, if you don't understand that, you won't understand the case. And I can't believe they were bamboozled by her innocence fraud campaign. I really can't. I'm always shocked every time because once you see it and you see the pattern, it's possible to unsee it. It's so obvious. They're not, no innocence fraud campaign is original. They all do the same things. They all make the same arguments. Blame the police, blame innocent people, usually people very close to the victim. They love to blame grieving people for the murderous crime. They love to re-victimize.
Okay.
We had the same suggestion. It appears that the court is not inclined to give it. If guilty, check one or both of the following. And there's a typo. It says the parenthetical
We fixed it.
check one of. Okay.
Yes. So we changed of to or.
So my only suggestion to that would be to, again, add the if guilty, comma, check one or both of the following.
Okay.
On that page, going down to the bolded parenthetical, same thing. If you find the defendant guilty of the lesser offense of motor vehicle homicide.
Okay.
Moving down under sub 5.
We
the
still
OUI
need to say stop and sign the verdict slip.
Right. After the word stop and sign the verdict slip.
Yep.
And then under sub 5, again, the same thing. We just suggested that for consistency that it says,
I mean, they're putting in subconscious things like just stop at not guilty. Don't go any further. You have to like press on. You have to have such a conviction to move forward in these things. It's okay. Just say not guilty. You didn't sign it. Move on. They had if this were the reverse, it would be so up in arms. You know, you click guilty and then just sign it.
say if
You're
guilty.
the worst, and there is no appeal for the victim's family. There is no appeal for the Commonwealth. That's it. If we find out that the legal team was up to more criminal behavior and Karen Reed is acquitted of anything, you can't retry her.
guilty, check one of the following of the both. And the final edit would be in the final parenthetical, the last sentence. If you find, I think her should be
Yeah.
changed to the defendant.
Sure.
If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1.
Okay.
And those are the edits that we have suggested for the verdict
All
slip.
right. Mr. Brennan?
I don't have any disagreement with the edits.
Okay.
The idea of instructing them on the nuance of selecting one guilty or not guilty, I don't need to be explained. I think that the edits, this proposed instruction explains it.
All right. What
I
I,
don't have any issue with if you state, if you decide on a lesser included offense, it does not include the earlier offense. I'm not sure of the exact language.
I'm going to lose it with this whispering. I just want to show you guys this. This is from Innocence Fraud Watch. Put this up. Thank you, Innocence Fraud Watch. Did operating a motor vehicle upon a way or in a place or which the public has a right of access or upon a way or in a place, so on or about January 29th, 2022. Where in the indictment did the Commonwealth ever allude to psychopathic murderer Karen Reed operating a motor vehicle under the influence of alcohol at 5 a.m.? It didn't. It didn't specify a time. Has a right of access or upon a way or to a place in which members of the public have access or invitees or license or without stopping and making known her name, residence, and the registration number of her motor vehicle did go away to avoid prosecution or evade apprehension after knowingly colliding with or otherwise causing injury to John O'Keefe. Such injuries have resulted in the death of said person in violation of MGL Code 9D. Okay.
I don't think that's necessary, but that is something I wouldn't have an objection to, but I think the form that you filled it out with would just going to be sufficient for them to follow.
what do you think about the defendant's position that if you were to find her guilty of operating under the influence, Mr. Jackson said explicit acquittal. I don't like that language. I think if you find it, it means you have found her not guilty of each of the others.
That would be fine with us.
I think it's better if you find her guilty of any lesser included offense, it would not include the higher offense.
All right.
I think that's just confusing.
So what I planned on doing was bringing them out and giving them each a copy of the amended verdict slip, explaining that it really is consistent with the jury instructions I gave them, but walking them through it. So we start from the top and then explain, if you find the defendant guilty, you're done. Stop, sign the verdict slip, and let the court officer know you have a verdict or something.
I prefer that.
Yeah, I think I'll walk them through it like we do in civil cases.
I don't have any objection to that. The only other thing is
Prefers it. Stop, you're done. I don't know why he agreed to that. I think it's worse. I don't know. That's the way I see it. I actually preferred what the defense had before. I thought I agreed with the defense. It was too confusing. I preferred what Alan
the
Jackson
digital
said.
instruction.
Yes.
We don't believe that it's necessary. I don't think that we should reemphasize that, and we're not asking for it.
All right, so you're waiving it?
We're waiving it.
Okay.
Yes,
All
thank
right, I will do humane instruction, humane practice instruction. So I need 5 minutes, and Tori, your computer, to amend this if we can, and we'll make copies. So we'll bring them here. Let them know that we'll be bringing them in shortly, Tony. All right, thank you.
All right.
Chloe Parker, did the jury hear John? I effing hate you. Yes, they did. Pug and Spice. Thanks so much. What a day. Thanks for all being here. Hit an all-time record of listeners. Maybe they're all hate listeners. I have no idea. Maybe they're all love listeners. Or maybe a mix of the both. Thank you. We've hit an all-time record for 6 o'clock listening on this subject. I'm going to take a quick break and cue this up. And when we get back, Judge Canoni's instruction to the jury, don't go anywhere. I will be right back after this very mellow break.
Mic check, Roberta strides through the static haze. True crime Gotham where the shadows play their plays. Fraudsters fold when a spotlight beams. Fact
Offensive
focused
motor
queen
vehicle
busting
homicide.
propaganda schemes. Glass shatter lies echoes through the streets.
With
Standing
the
for
jury
victims,
instructions I
giving
gave
voice
you,
their beats.
but it's a little bit easier for you to follow. And for purposes of going through,
exposing, she's the anti-fraud light.
all right, so I'll take thank you.
Hard cash warrior, dissecting state and defense, twisted innocence, claims breaking pretense. Gotham's truth seeker cuts clean with the blade. Facts in the forefront, no justice gets swayed. Cold facts drip heavy, real talk unfurls. Cracking cases open like oysters with pearls. Innocence gimmicks crumble to dust in the wind. For victims,
Okay, we're back. My computer's all wonky. I don't know. I'm sorry, guys. It's wonky. It's about to clunk out. It's had enough, too. It's had enough. It's wonked out from injustice. Yeah, it is like a horror movie.
All right, the court, please. Your statement. Let's back to session. You may be seated.
All right, jurors, we're in receipt of your question. We've been working on making sure that the answers we give you are the right ones, so it's taken us a while. So the first question, what is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The answer to that question is that you folks have all the evidence. And remember, it's only you who decide the facts in this case. All right, that's the answer to that question. You are the fact finders. The second question, are video clips of Karen's interviews evidence? How can we consider them? Yes, the videos are evidence. You should weigh the defendant's statements in the videos as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven.
Yeah, like Karen Reed, like maybe they can go off in their mind and consider that Karen Reed might have given false confessions to a documentary film crew.
Beyond a reasonable.
And none of that was ever really explained what these clips were they?
Doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. So that's the answer to that question. So for the third question, does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? So with that what I'm going to do is I have amended the verdict slip. It's the exact same verdict slip, and it's still consistent with the jury instructions I gave you, but it's a little bit easier for you to follow. And for purposes of going through this, we'll go through it together, and I've got a copy for each one of you, okay?
Listen to these fakakta jury slips. They're wild. Get ready for wildness. Getting rid of the buffer zone was the absolute worst decision ever. She made her Massachusetts the laughing stock of the world.
All right, so you'll see it really is the same verdict slip, but we've added a little bit of language to help you follow it through. So the first charge, manslaughter while operating a motor vehicle under the influence of liquor. So first, in the above entitled case, we say the defendant is, 1, not guilty of the offense charged or any lesser included offense. If you find the defendant not guilty of the offense charged or any lesser included offense, stop and sign the verdict slip. Now, then you go on to guilty of the offense as charged, manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following: manslaughter while operating a motor vehicle under the influence of liquor, and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip. That means on each one, when you stop and sign the verdict slip, that means you have a verdict on this indictment. So stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence of liquor, then continue below to the lesser included offense. And first, under 3 is involuntary manslaughter. If you find the defendant guilty of the lesser included offense of involuntary manslaughter, stop and sign the verdict slip. If you find her not guilty of involuntary manslaughter, then continue to the next page. Guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence. And you have to check one or both of the following: motor vehicle homicide under the influence of liquor, and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below to the guilty of the lesser included offense operating under the influence. And you check one or both of the following: operating a motor vehicle under the influence of liquor, and or operating a motor vehicle with the blood alcohol level of 0.08 or greater. If you find the defendant guilty of operating a motor vehicle under the influence of liquor, then stop. If you find the defendant guilty, you stop and you sign the verdict slip. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1. And remember,
You know, we stand up for what is right. We don't do it because we think we're going to win or we think we're picking the winning side. We do it because it's right. That's it. End of story, right? And this is, I mean, if you're wondering why there's not so many people who speak out about this issue, it's tough. We lose a lot. We lose a lot.
remember, your decision must be unanimous. All right, does that make it any clearer, hopefully? All right, so with that, I am going to send you back out.
Before the jury's set,
Sure, why don't you come on over?
Is the judge communicating on an encrypted app? Is the jury communicating on an encrypted app? I don't know. You know, I think a big start would be, I'm not even going to go over the last thing was even worse, okay? Can we acquit on 2 charges and hang on the next? It was just a short moment. But that was the 4th question. And that was the first question in that whole line of questions. I mean, it couldn't have been a worse question. Hold on. Oh, then there was this. Sorry, I forgot this moment. Hold on 1 second. To give you a full understanding. Let me go back a minute or two. I mean, I'm just heartbroken for Peggy O'Keefe and if you didn't really come to love John O'Keefe in this story, you weren't paying attention. So it's just a heartbreaker for all of us if this is, the way it's going. And even if we got great convictions, the fact that Karen Reed is being treated like a celebrity and just the media reports are so disgusting. So pro Karen Reed, everything is painted in the best light to Karen Reed. The only time we've had a critical question is Carl Dougal or whatever. Sorry, I don't know. Terrible at names. Asking, well, why did you admit to it? Yeah, like 3 or 4 times. They don't ask the second question. They don't ask the first art question, let alone the second question. That's the best journalism out of this case. Wasn't even a journalist. It was John O'Keefe's friend. Did the best journalistic work in the entire case with that one question. Why aren't we getting more critical questions? And the people who think she's guilty are asking the same kind of softballs. Oh, really? Did Peggy O'Keefe lean over the counter? Why do you think she's denying ever saying that? You're saying she did say? Was he looks like he got hit by a car. Oh, really? Did say that? Because no one else said you had coffee that day. They said you snuck in like grave robbers, took your stuff and snuck out. Didn't hug the children, didn't console them, didn't care, cared about yourself. Number one, that's Karen Reed's MO.
I heard myself say this, and I'm glad counsel told me I did. So if you go back and look at the form after 4, if you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony, OUI, liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below. I think I said then find, I don't know what I said. I heard myself read the guilty of the lesser included offense. So if you find her not guilty of motor vehicle homicide under the influence of liquor, then you continue to decide whether the Commonwealth has proven to you beyond a reasonable doubt that she's guilty of operating under the influence of liquor. And if they have not, and if you find the defendant not guilty on this offense and all other offenses, then you go back and check the first box. So you follow it from the...
How did the Commonwealth agree to this crazy jury sheet? I don't know. They can't simplify it in any fairer way. Chloe Parker, thoughts on the night's sleep will do a jury? Not much. Everything out there is saying free Karen Reed. It's Karen Reed's the victim, up against the big bad man, the state. Yeah, me too. I feel bad for the O'Keefe family. Yeah, that's the kind of day it was. It started out good. We thought maybe it was 3 questions sounded kind of good for the Commonwealth. Can we use our own words? He has evidence. Yes. Yeah. She's framing other people. She's trying, but there's no evidence. So no one else is getting arrested. All roads lead to Karen Reed. Karen Reed drove over the limit that night. I think she's a habitual drinker. 2 to 3 times over the limit. Reversed her car into John O'Keefe, hit him, and drove away. Hit him with her foot 75% down on the gas pedal. The minute her car hit him, that's when John O'Keefe was flung to the lawn and never moved again. And you can see the temperature of his iPhone just drop over time. He wasn't in the basement. He wasn't in the garage. He was on the dark side of the Albert's lawn all night. Karen Reed knew where he was. She thought he looked mortally wounded, and she protected herself. I think she took a look at him and drove away and left him there. This was to teach John a lesson. How dare he leave her? That's the story. That's the truth. It doesn't change. It's not particularly interesting. But it doesn't change. It's the same story. His phone never moved after that moment. It wasn't beat up. There was no dog. People give away their dogs when they don't get along with other dogs. It happens. People move houses, especially after a traumatic event like that. That's what happens. That is life. It's not dramatic. It's not going to be a TV movie of the week. It's just sad. It's just the end product of a coercively controlling relationship or a DV relationship, whatever you want to call it. That's the story. That's what I have for today, guys. Please hit the thumbs up. Please support the channel. I'm working hard to keep you abreast of everything that's going on in the Karen Reed case. I'm here in the morning, still back tomorrow again on jury watch, verdict watch. We'll all get through this together, even if the worst happens and she's acquitted of all 3 charges. We'll still be here and we'll still think she's guilty. Okay. Right. We'll all support each other and get through it. All right. So please support the channel. Links are in the description of this episode. You can buy me a coffee, send me a Venmo, become a Patreon and get access to exclusive content you won't get anywhere else. My boyfriend wants to say something. What, honey?
If she gets acquitted, I'm gonna poop.
You're gonna poop if she gets acquitted?
I'm gonna lose my poop.
You're gonna lose your poop? Okay. There, you heard it there first. Even my boyfriend who originally got brought in by the conspiracy, go back to the first episodes, right?
It looked like a dog bite to me.
Yeah, he was brought in by the dog bite.
I was
Even
bitten by a dog once when I was a little kid, so
that must have. Did he leave? Did he leave a tiny little no puncture wounds? He just sort of scraped the. That must have been the nicest dog bite in the world.
I was wearing a very thick jacket, and I was 5 years old. But I do remember the dog biting and not getting a good grip, and then biting again. And so, yeah, I mean. I guess I believe them, but that's why we need real experts, not experts that think dogs can bite with no chin.
You see my dog bite? It's like my whole side of my face had to be reconstructed. I mean, 8 stitches, and I had to wait for.
No, that's not a good example because you look beautiful.
Thank you, but you didn't see it. It was much worse when I was 6 and 7 years old. They don't play bite. They go to make damage. Dogs do when they're biting. All right. I'm out. I'll see you guys tomorrow at 8:40 in the morning, okay? We'll all be there for each other. I'm a no innocence fraud broad. I hope you are too. Keep speaking out. Keep telling the truth. I'll see you tomorrow. Thanks, guys, for listening. You're the best.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment. I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the was snowing. I pushed the pedal down, hit him hard. Now the legal system I clown.